So, my ladies, my lords, the issue was non-justiciable because it was political. It was political for two reasons. One was that it trespassed on the proper province of the executive, and the other was the lack of judicial or manageable standards by which it could be determined. And I paraphrase, of course, from the opinion of Laws Newberger, Assumption, and Hodge in the case of Shergill. Much reference has been made to constitutional principle. Constitutional principle may embrace legal rules, but it may also embrace convention. Convention that is not amenable to enforcement in a court of law. And an example of that was seen in Miller 1 in reference to the Sewell Convention, which was expressed in statutory form, but nevertheless remained a convention for all that. In order to proceed under the heading of constitutional principle, there has to be an element of legal content. And if you take the example that was cited by my learned friend Mr. Fordham of the Unison case, there one could clearly identify the legal right of access to justice, and therefore rely upon that in order to determine the declaration of a right and the enforcement of a right. Here we have reference to what is termed parliamentary accountability. But what legal content does that concept actually embrace, as distinct from its practical and factual content? Ultimately, what this court is being invited to do is to control the length of the prorogation of Parliament as exercised under the prerogative. The length of each session of Parliament and the frequency between sessions is regulated by constitutional convention and not by the law. And of course, that was not always the case, because very early on, Parliament enacted the Triennial Act, which determined that Parliament could not be prorogued within 50 days of it having been summoned. And then in the Triennial Act of 1664, that provision was repealed expressly on the basis that it was in derogation of the exercise of the prerogative with which we're concerned. And since then, Parliament has not sought to legislate generally in respect of prorogation, having had an opportunity over more than 300 years to do so. Of course, it has legislated in order to determine that in certain occasions, on certain times, it should not be prorogued, but will be recalled. And the most recent example, which has been repeatedly referred to, was Section 3 of the Northern Ireland Executive Formation Act. There have been efforts to distinguish the exercise of dissolution from that of prorogation. Dissolution has been repeatedly identified as forbidden territory for the courts. It is not justiciable. And yet, the distinctions that have been drawn between that and prorogation are far more apparent than they are actually real. In respect of dissolution, of course, Parliament cannot be recalled, and there will ultimately be an election. Following that election, of course, it's provided by the Act of 1694 that Parliament might not be summoned for a period of up to 3 years. Even in the period from dissolution to election, and I'll come on in a moment to look at that period, the executive would remain in place, and indeed would remain in place during the period when Parliament had not been summoned following an election. Of course, we now have a decision by Parliament to regulate dissolution by primary legislation, the Fixed Term Parliament Act. Under the terms of that Act, and the periods are quite instructive, I will suggest, the period between dissolution and an election must be 25 working days or 35 calendar days, including bank holidays, during which time the executive will clearly not be accountable to Parliament. And thereafter, as I say, it will be for the executive, essentially, in their exercise of prerogative powers, to determine when Parliament will actually be summoned thereafter. Now, in respect of prorogation, it is clear that political purposes may very well prevail over any formal purpose or requirement for prorogation of Parliament. And we've seen many instances of that over the years. If, in the event of prorogation, Parliament takes exception to that course of action, it has a very clear route to adopt. It may, following the prorogation to which it took exception, or in anticipation of the prorogation which has not begun, because that would be the instant case, at the beginning of September of this year, move a motion of no confidence in the executive. And such a motion, if moved by the leader of the opposition, would be heard. So, if it has notice, as it did have, that it was to be prorogued for a period that it took exception to, or at a time to which it took exception, it was perfectly free to move a vote of no confidence.
What if it conceived that that would not be to its political advantage?
The Lord makes the very point I was coming to.
I'm sorry, I keep anticipating your points. Do forgive me, Lord Keane.
That is precisely the point. It is then a determination of political advantage as to whether or not such a motion is made, and indeed the same can be said about the ability of Parliament to move a motion in terms of the Fixed Term Parliament Act. And such a motion was, of course, moved in anticipation of the prorogation, but the opposition chose to abstain. Again, an entirely political act. They did not wish to go to the country. They did not wish to go to the people. We've heard the suggestion that dissolution is different because the executive is then answerable to the people. Well, by way of prorogation, again, the executive may very well be answerable to the people if Parliament takes exception to the prorogation that has been proposed. So I respectfully suggest that the attempt to draw some distinction between the justiciability of the dissolution of Parliament, which of course prior to the Fixed Term Parliament Act would be determined as a political act essentially, and that of the exercise of the prerogative of prorogation is simply not worthy of any detailed examination. The results may very well be the same. The political considerations of all sides of Parliament are bound to be very similar, and the act of the executive can always be the subject of scrutiny, ultimately by the people in the form of an election. should Parliament choose to adopt that route. But as the Lord Kerr observed, they may decide that it is not politically convenient for them to achieve that consequence. So that is where we stand so far as the issue of justiciability is concerned, whether it be dissolution or whether it be the prerogative of prorogation. This is forbidden territory. It is a matter between the executive and Parliament. And if Parliament takes exception to the executive, they have the tools available to address the matter. If they choose not to employ those tools, that's a political matter. It is entirely for them. And I just add this one further point. How, in the context of that political minefield, is the court to opine on the issue of purpose or improper purpose, or legitimate political purpose or illegitimate political purpose? How are these concepts to be defined and applied in this context? In my respectful submission, the applicants and the petitioners are inviting the courts into forbidden territory and into what is essentially a minefield, an ill-defined minefield that the courts are not, with the greatest of respect, properly equipped to deal with. Can I turn from there to some of the particulars of the appeal in the case of Cherry? And the first point I would wish to make is simply this, and it may have been noted by the court already. In his submissions, my learned friend Mr. O'Neill made no attempt whatsoever to respond to the criticisms that I'd made of the reasoning of the Inner House, or indeed to defend the particular and inconsistent approaches taken by the Inner House in the determination of that case. And in my submission, the reasoning, for the reasons or on the grounds I set out before, is unsustainable, and it must follow that the issues in that case are for this court to determine, which they may do properly by reference to the documents. I should also notice the suggestion from Mr. O'Neill that a concession was made in the Inner House about justiciability. I was not present in the Inner House, but I've had the opportunity to speak to both Mr. Johnston and Mr. Webster, who were present, and also to look at Mr. Webster's notes. They do not consider that any concession was made, but if it was, it is hereby withdrawn. So if I could make that clear with the permission of the court.
Thank you for that clarification. We'll keep...
One always proceeds on the basis that if something is stark staringly obvious, a concession is not required, and if it's not stark staringly obvious, a concession is not appropriate. Now, furthermore, my learned friend Mr. Fordham suggested that Sir James Eadie had made a concession as to justiciability, but again I take exception to that. If Parliament has by primary legislation sought in any way to determine when or whether the prerogative of prorogation should be exercised by the executive, then of course this court is entitled to interpret and apply that primary legislation. But I suggest that gives no doorway into the general issue of justiciability of the prerogative power of prorogation. So I would seek to put that point as made by Sir James into its proper context. Turning very briefly to the issues that arise if this court now has in hand the appeal itself, I simply urge this court to do as the Lord Reid suggested yesterday, and that is to consider fairly and as a whole the documentation, the contemporaneous documentation, the authentic contemporaneous documentation that has been produced in this case. And I'm not going to go back to the comments I made about affidavits in the context of a Scottish process. I simply notice that the Lord President was perfectly satisfied that an affidavit was not in these circumstances required, and that is also consistent with the dicta of Lord Walker that the court was referred to, where he felt that if the documents spoke for themselves, then it would not be required. The language of the documents is important. I have to notice that my learned friend Mr. O'Neill used discourteous and indeed incendiary language in describing ministers, advisors, and civil servants. That language is wholly unwarranted, but it does reveal an error in his approach. If you approach the documents with a preconceived belief and mindset that they are a sham, then of course that will lead you to a particular conclusion with regard to the construction of some passages in those documents. If, on the other hand, as I would submit, you read them fairly and with an open mind, and they are obviously authentic documents, and you realize that they give considered advice to the Prime Minister and properly record a formal cabinet meeting, then I say a different picture appears. And I simply commend that approach, that interpretation to the court. There was a complaint, of course, that somehow prorogation prevents accountability. Well, it is a fact that for a period, prorogation will affect accountability in Parliament, but it doesn't prevent accountability beyond Parliament, where again the executive will be questioned and held to account, whether by the public, the media, or indeed during a party political conference season at each of those conferences, no doubt. But prorogation no more intrudes upon the idea of accountability than would dissolution. And again, I cite the point that even under the Fixed Term Parliament Act, there will be no accountability of the executive to Parliament for a period of 35 days after dissolution. And nothing can be done in that period because Parliament could not be recalled. Whereas in respect to prorogation, there are, of course, a series of statutory mechanisms that may be employed for that purpose and according to particular circumstances. So again, if one was to fall back on the comparison with dissolution, I would suggest that in fact, prorogation is so clearly a matter that is political in nature that it falls within the forbidden territory. Now, a number of questions were raised, including by my Lord Sale, about the effectiveness of post-prorogation controls. But in a sense, the same arises with regard to dissolution. If there's dissolution and the government goes to the country and it's re-elected, it may be held account for the grounds upon which it sought to dissolve for political purposes at a particular time. So there's no greater and no lesser a degree of control. Of course, the ultimate political control, whether it be prorogation or dissolution, is the ability of Parliament to express no confidence in the government, and is the ability to take the government back to the country. And when looking at all of this, we mustn't forget that one of the primary aims of the opposition in Parliament is to replace the government. They're not just there to hold them to account, they're there to replace them. Just as the government has a political imperative to pursue its own policies, so the opposition has a political imperative to seek to pursue their policies. And that is all part of the political ground where the courts should not be. Now, in passing, and towards the end of his submissions, the learned friend Mr. O'Neill asserted that the United Kingdom could not leave the European Union without a deal unless that was authorised by further primary legislation. And that was apparently because departure would impact upon individual rights. I don't want to dwell on this point. It arose in the inner house, but not before Lord Doherty in the outer house. Our note of argument in the inner house addressed this issue at paragraph 66 to 70, which is MS 415. I should just add that Mr. O'Neill's case was directly rejected by Lord Drummond-Young at paragraph 110 of his opinion, that's MS 1245. It was rejected as a relevant challenge to prorogation by Lord Bronte in paragraph 71 of his judgment, that's at MS 1208. And the Lord President rejected that prorogation could have any effect on individual rights, that's at paragraph 59, MS 1212. So, in my respectful submission, the submissions by Malone from Mr. O'Neill do not take him to where he would wish to be, and the appeal should be sustained on the unchallenged grounds that I sought to advance in opening before the court. Now, the court will be aware that we produced two further notes, and it's perhaps appropriate that I should make reference to these. If I could deal first of all with the note on the effect of prorogation on legislation. There was some discussion of this yesterday, and we've addressed the factual and legal position in the note that we produced this morning. In short, the government is and has for a considerable period been alive to the need to ensure that the statute book is prepared for exit from the EU and has taken extensive steps to achieve that result. And of course, most of that work was actually done earlier in the year in anticipation of an exit on 29th March. Some further statutory instruments are required to address changes, essentially changes in EU law since March, and those are largely of a technical nature. The 2018 Act, of course, provides for an urgent process for the making of statutory instruments, and in the small number of instances where such SIs need to be in place for exit, they can and they will be in place. Now, of course, all such SIs must be debated within 28 days or they lapse under the affirmative procedure, and the government considers that there will be an opportunity to debate all of these before 31st October, and it won't be a case of addressing a debate on these instruments after that date. So I seek to reassure Lord Lloyd-Jones on that point. In these circumstances, we expect that there will be adequate time to deal with all SIs and indeed with all required primary legislation. And in that context, I should stress that some of the Brexit-related primary legislation that's been referred to by the PLP, for example, the 5 outstanding bills, are not required as at exit date. And we seek to give an explanation for that in the note that we've provided. They are issues that will be addressed going forward after 31st October, assuming an exit on that date, but they're not actually required on that date itself. I should say that there was some element of confusion in the minds of some about what bills were being referred to by the PLP. And at paragraph 3 of our note, we say in paragraph 5 of his second witness statement, Dr. Joe Tomlinson for the Public Law Project suggests that all Brexit bills from the last parliamentary session have fallen. Insofar as that statement suggests that all Brexit-related bills from the last Parliament session fell at prorogation, that is not correct. And we point out that many of them passed, but there were 5 remaining. I should add, in fairness to Dr. Tomlinson, that if you go back to paragraph 37 of his first witness statement, he's referring there to the 5, not to the totality. And I would wish to ignore that. I think there's been a misunderstanding on that point. The second matter that has been the subject of a further note is the matter of relief. And we have sought to explain why, as Lord Reid anticipated, this might be a little more complicated than it first appeared. what cannot remain is part 4 of the interlocutor of the inner house. But what I would observe is this, that while we go in detail through these matters, and while we do maintain very strongly that the prorogation of Parliament did take effect, notwithstanding the complaints made by the applicants and petitioners, and that Parliament is prorogued, and that the prorogation cannot be impugned, standing Article 9 of the Bill of Rights. There is room, of course, for the court to make a declarator or declaration if it comes to the conclusion, contrary to our submissions, that the advice given to the sovereign was unlawful. But that, I venture, is all that would actually be required in the context of this case, a declaration that the advice was unlawful. And it would then be essentially for Parliament and the executive in particular, to decide how to respond to that, considering the reasons that may be given by the court if it comes to that determination.
Is your position that if such a declaration were made, the order in council, the prorogation effected by the commissioners appointed by the order in council would be legally effective?
Yes, my lord. That is our position. And I just pause.
And then how would it be? How would it then be that it would be for Parliament to decide how to respond? Because Parliament wouldn't be there.
I'm just going to say, in the first instance, it would be for the executive to respond, and under the 1794 Act, they could, of course, seek an order in council for a proclamation for the recall of Parliament.
But it seems very strange that Article 9, which historically was there to protect the privileges of Parliament against the executive and the Crown, would then have the effect contrary to that purpose.
Well, I don't accept the proposition in those bold terms, if I may respectfully say so. It appears to me that the first question is, was the proclamation by the Lords Commissioner a proceeding in Parliament? And we've given 6 reasons why that must be the case. And if it is a proceeding in Parliament, then it falls within Article 9 of the Bill of Rights.
But why shouldn't one start at the other end and see whether they were properly charged, lawfully charged, to deliver their message to Parliament?
Because one would...
And it's being said on the other side, the answer is that they were not.
Ultimately, that would mean impugning the proceedings in Parliament that have taken place, and the consequences of that could be far-reaching. I would suggest, well, first of all, we say that the Order in Council itself is linked to the proceedings in Parliament. But more particularly, the third stage of the process, the declaration by the Lords Commissioner, prorogue Parliament.
But if
the reasons it did so may be impugned as having been secured by some means that was not appropriate. They may be impugned on the grounds advanced by my learned friends on the basis that the advice given was unlawful. But the sovereign made the decision on the advice of our Prime Minister. The Order in Council was made, and the declaration was a proceeding in Parliament.
But my Lord's question is this. Go to the anterior stage. If the advice given to Her Majesty the Queen was unlawful, then the relay of instructions to the Lords Commissioners, I should have thought, was also unlawful and can be impeached at that stage before they go anywhere near Parliament.
The Lords Commissioners may be entirely unaware of the advice given.
But whether they're unaware of it or not,
they have their commission under the Great Seal.
Yes, I appreciate all of that, but they they can only act on instruction from Her Majesty the Queen. And if the advice that she has been given is unlawful, then the instruction that she gives to them to act, whether under the Great Seal or otherwise, likewise seems to me to be unlawful, is it not?
If I may respond in this way. If Her Majesty, having received the advice of her minister, had entered Parliament and prorogued it in person, would that prorogation be amenable to challenge in this court?
Well,
I
I
submit
don't know that that's all that helpful, to be honest, because the circumstance is that she receives advice which, let's say for the sake of discussion, is unlawful. Then she cannot convey to the, and it's nothing to do with the Queen, of course, where she's simply performing her constitutional function, but the advice or the instruction that she gives to the Lords Commissioner, so the argument goes, cannot be valid since it was based on unlawful advice. So it's at the stage before it gets anywhere near Parliament that the attack on the lawfulness of what is to take place occurs. Is that not right?
No, the attack which is made in these applications is on the lawfulness of the advice, and it doesn't go beyond that.
If the advice was unlawful, would it not follow that the order in council was liable to be quashed?
Well, I would submit that it is not liable to be quashed because it is incidental to the proceedings in Parliament and therefore falls within the ambit of Article 9.
That sounds like putting the cart before the horse.
I say that we should actually start by recognising that the prorogation was a proceeding in Parliament which falls within the ambit of Article 9 of the Bill of Rights, and we don't have to go further than that.
And am I right in understanding that no undertaking is being offered?
I indicated to the court in opening that the Prime Minister would take all necessary steps to address any decision of the court that determined that the advice was unlawful.
That sounds like something which really ought to go without saying.
Exactly so. It is not for the executive to give undertakings to obey the law. The executive does obey the law, and if the courts tell us what the law is, we will address that.
There.
Just so I'm clear, and I just want to understand the position, are you saying that the word impeached in Article 9 covers a case where a consequence flows from an order of the court?
I'm saying that the proceedings themselves are protected by Article 9.
So the court's order wouldn't have consequence.
My lady, my lords, unless there are further matters that you would wish to raise, having adopted the 2 additional notes, I would rest my submissions there.
No? Thank you very much, Lord Keane. Thank you. I suspect that Mr. O'Neill may be correct in saying this case is unique in having 3 members of the House of Lords addressing it.
Whether that's an advantage the courts may not need to pronounce upon.
Or perhaps a precedent.
My ladies, my lords, I gratefully adopt the submissions that the court heard this morning from the Lord Advocate, from Mr. Fordham and from Lord Garnier. The court has received comprehensive oral and written submissions over the last 3 days, and I therefore wish in my reply just to emphasise what we say with respect are the central errors in the arguments advanced by my friends Lord Keane and Sir James. And may I say something about the facts and then the law, and then can I address the remedy, as my friend Lord Keane did. Now, on the facts, we say the central issue is why was it appropriate to prorogue for 5 weeks, longer, as the court knows, than on any occasion in the past 40 years. And Lord Keane's response when this question was put to him was that the prorogation was not in substance for 5 weeks, because 3 weeks of the period would have involved the recess of Parliament for the conference season. Therefore, in truth, the prorogation is for 7, I think he said, 7 working days of Parliament. Our response is we say that does not explain, far less justify, closing Parliament for 5 of the 7.5 weeks prior to the 31st of October, having regard, of course, to the adverse effect on the ability of Parliament to perform its scrutiny functions at this critical time. Why do I say that? Well, because first, as Sir James and Lord Keane both accepted, it is Parliament, not the executive, which decides whether to have a recess for the conference period. Parliament may or may not have decided to have a 3-week recess this year when the 31st of October is fast approaching. The Prime Minister's decision took that matter out of the hands of Parliament. Secondly, even if there was a conference recess this year decided upon by Parliament, Parliament would still, during those 3 weeks, have been in session. And therefore, written parliamentary questions could have been asked and would have needed to be answered. And parliamentary committees could report and would report. The court knows that it's been a regular feature of the past few months, at least the last few months, that parliamentary committees have been reporting and reporting urgently on all aspects of the Brexit process. So some degree, an important degree of parliamentary scrutiny would still have been available. And this prorogation for 5 weeks at this time prevented any parliamentary scrutiny for that period. And the third answer to Lord Keane is the point put to him by my Lord Kerr and my Lady Black. And your Lordship and your Ladyship asked Lord Keane to explain why there was any need for a prorogation prior to the 7th of October or thereabouts. What was the reason? And there was, in my submission, no answer to that central question.
Prior to which date did you say?
The 7th of October, a week or so, not precisely, but around the 7th of October. What was the need for a prorogation prior to that date, was the question put, if I understood correctly, by my Lord and by my Lady. Yes. And I say, court heard the answers, I say there was no coherent answer to that question. The documents on which Lord Keane relies in relation to this whole matter include, let us not forget, the note dated the 16th of August in the Prime Minister's own handwriting. It was read out yesterday by my friend Mr. O'Neill, and I don't ask the court to go back to it, but it's in the Miller Trial Bundle, tab 39, page 316, electronic page 379. And it's the one where the Prime Minister says the whole September session, these are his words, is no more than a rigmarole to show the public MPs earned their crust. That's what it says, and that's his words. And I'm very happy for the court to follow Lord Keane's approach that he articulated a few moments ago. Read this document fairly and with an open mind. There's no need to adopt any incendiary language, Lord Keane's criticism of my friend Mr. O'Neill. The document speaks for itself. And what does it show? It shows the Prime Minister's failure to understand that Parliament, as the sovereign body, will wish to ask questions of the executive, to debate matters, to report through its committees, possibly enact more legislation. And it will wish to do so during these September weeks concerning the negotiations, if any, with our European partners and the planning for no deal. And I was asked on Tuesday by my lady, Lady Arden, about the bills that were lost because of the prorogation from the 9th of September. And the court now has the answer, detailed answer to that question. And there's no dispute. The government's note accepts that a number of important bills have been lost. They include, incidentally and sadly, the Courts and Tribunals Online Procedure Bill, on which, if I may say so, Lord Keane worked tirelessly and skillfully to pilot through the House of Lords. It's one of many bills that have been lost. Now, Sir James points out, and he's absolutely right, that it is inherent in prorogation that bills are lost. But my lady, Lady Arden's question is important because it provides a further answer to the Prime Minister's suggestion in his handwritten note that I mentioned a few moments ago, that Parliament has got no business to transact during this period. So what's all the fuss about? The bills, some of them very important bills, that were being debated, that were going through the stages of both the House of Lords and the House of Commons, demonstrate the error in the Prime Minister's analysis. And we therefore maintain our factual submission made in opening that this 5-week prorogation has prevented Parliament from carrying out its scrutiny functions over the executive for a period of exceptional length, longer than any prorogation in the past 40 years, for no rational reason, and at a time when the constitutional principle of the executive being answerable to Parliament is of vital importance. All of this conflicts, and I'm coming on to the law, with the constitutional law principle that the executive is subject to parliamentary scrutiny. And it's enough for our case to apply, as the Deputy President put to me on Tuesday, the Padfield principle that a minister can be shown to have acted unlawfully in the exercise of a discretionary power because of the effect of the decision. And my friend Mr. Fordham was absolutely right this morning to emphasise that my Lord the Deputy President's judgment in the Unison case is again based on impact. It's not based on there being any need for a malign motive. But I add, if necessary, and on my case it is not necessary, I would go further, if necessary, and invite the court to draw the inference that the length of the prorogation was motivated, or at least strongly influenced, by the Prime Minister's wish to prevent scrutiny by Parliament, because he regarded Parliament as a threat to the successful implementation of his policies. There is no rational reason for a 5-week prorogation, giving the Prime Minister the broadest possible margin of discretion. And if that's right, the court is entitled to draw an inference that there was an improper reason. See Padfield. I remind the court that in opening I referred to 2 interviews given by the Prime Minister himself on the 30th of August. It was our trial bundles tabs 54 and 55. The court will recall it was a BBC interview and a Sky News interview. And in each of those, the Prime Minister himself stated that Parliament was a threat to the implementation of his policies. Neither of my friends, Lord Keane nor Sir James, addressed that evidence. The documents on which the government relies are of limited assistance to the court because there is no witness statement by or on behalf of the Prime Minister telling the court that they contain the only reasons for a 5-week prorogation. May I turn to the law? The argument advanced by both of my friends has two main limbs. First, they say the issues are not justiciable. And second, they dispute that there is any relevant principle of constitutional law. We respond that those 2 points go together. If, as we submit, there is a relevant principle of constitutional law, that is the supremacy of Parliament and the inferior status of the executive and its accountability, then it is a question of law for the court whether, in the light of that principle, this decision is outside the proper scope of the legal power to advise on prorogation. Sir James accepted, and properly so, in answer to my Lord Kerr, that it is for the court to decide the proper scope of a prerogative power. We submitted and we maintain the submission that parliamentary supremacy is a principle of our law. It is as fundamental as the rule of law and access to justice. It is not a mere convention. And it is not confined, as Sir James submitted, to an obligation on the executive and the courts to comply with enacted statutes. That is a consequence, an important consequence, of parliamentary sovereignty. But another feature of the legal principle of parliamentary sovereignty is that the executive is answerable to Parliament. And it therefore follows, we say, that the executive, the junior partner, cannot claim a legally unfettered power to close down the senior partner for as long as the executive likes, for whatever reason it likes, and however substantial the damage to the ability of Parliament to perform its scrutiny functions. Sir James then said that for the court to intervene would breach the principle of the separation of powers. Our answer is that the court is being asked to intervene in order to uphold the separation of powers. That is to ensure that the executive cannot, by its own acts, escape from scrutiny by Parliament. Sir James then says there are no judicially manageable standards. He points out correctly that any prorogation involves a limitation on parliamentary sovereignty. He asks how many days of prorogation is lawful? What reasons may justify prorogation? Our answer is that the court will, in this case, carry out precisely the function that it performs in other public law cases. It applies the relevant legal principle, here the supremacy of Parliament and the answerability of the executive, to the circumstances of the case. It looks at the length of the prorogation. It looks at the reasons given for the length of the prorogation. It looks at the adverse impact on parliamentary scrutiny. It looks at any inferences the court thinks it appropriate to draw as to whether at least part of the motive was to avoid parliamentary scrutiny. And having done all that, the court asks itself whether, in the light of all those circumstances, and applying, I accept, a generous margin of discretion in favour of the Prime Minister, whether his decision, his advice, is beyond the proper scope of his powers. This is standard business in judicial review in all other contexts? Was this decision reasonably necessary to further a legitimate objective, conferring a broad margin of discretion because of the context? And I say it is not, with great respect, it's not the function of the court to identify all the circumstances in which prorogation would be lawful. And the court does not need to supply a bright line standard, an algorithm, to answer all circumstances. A good example of that is the judgment of my Lord the Deputy President in the Unison case. The fees charged by the Lord Chancellor to those wishing to bring proceedings in the Employment Tribunal were unlawful, and they were unlawful because of the adverse impact on the constitutional principle of access to justice. And they were unlawful even though it would be lawful for the Lord Chancellor to charge some fees. And the court was not identifying, how could it, where the dividing line would fall. Sir James then referred to various acts of Parliament, including the recent Northern Ireland Act. And I say none of them assists in this exercise because none of them can be said to involve a parliamentary intention to remove the obligation on the executive only to exercise its powers in a manner lawful under the relevant principles of our constitutional law and our judicial review. Then finally, Sir James relied on the fact that the authorities have suggested that the power to dissolve Parliament is unreviewable, and the court has expressed interest in that matter. I respectfully agree with what the Lord Advocate and Lord Garnier submitted this morning. Dissolution of Parliament serves a vital constitutional function in ensuring democratic accountability of the members of the House of Commons. But I add a further factor. Prior to the abolition of this prerogative power in 2011, it was unreviewable because it was a personal prerogative of the Crown. See RFV Houston, Essays in Constitutional Law, its authorities, our authorities, the Miller authorities, Volume 5, Tab 81. And the relevant passage starts at page 75 and continues to address this question at pages 79 to 80. Now, my Lord Carnworth asked Sir James whether it was his submission that Her Majesty does enjoy a personal prerogative in relation to prorogation of Parliament. And Sir James was very clear in his answer. He said, I am not making any such submission. And that answer, the court will recall, is consistent with what happened in this case. I showed the court in opening the radio interview with the President of the Council, Jacob Rees-Mogg.
I think he said, I'm not making any positive submission to that effect. But
yes, I'm not making any such submission. It's no part of his case.
No,
it's no part of his case. And it's our argument is to the contrary. And I say it is entirely understandable why Sir James did not make a positive submission that Her Majesty does enjoy a personal prerogative in relation to prorogation. And the reason, I respectfully submit, is that given in argument by my Lord Sales. It would be profoundly unsatisfactory in a constitutional democracy governed by the rule of law if the court were to conclude that there does not need to be any legal controls on this power because any abuse can be addressed by Her Majesty. That would place Her Majesty in a quite impossible position. Remedy. The remedy we seek from the court is a declaration that the Prime Minister's advice to Her Majesty was unlawful. And we would respectfully ask the court, if it is in our favour, to make such a declaration as soon as possible, no doubt for reasons to follow. As soon as possible, because time is of the essence. We do not accept the argument, respectfully do not accept the argument advanced by my friend Lord Keane, that Article 9 of the Bill of Rights immunises the order in council or any action that was taken in reliance upon it. And that is because the order in council was based, if our submissions are correct, on unlawful advice. The order in council is not a proceeding in Parliament. It precedes the proceedings in Parliament. And therefore, if necessary, we would argue that the court is able to give further relief. However, we would expect, in the light of a declaration, that the Prime Minister will ensure that Parliament resumes as soon as possible next week. And we consider that the appropriate way forward is for these matters, in the light of a declaration, to be addressed by the Prime Minister, by politicians, and by the parliamentary authorities. And we recognise that unless it is necessary to do so, this court will understandably be reluctant to grant further relief. The court understandably will be anxious not to take any steps that may be seen as trespassing on the exclusive right of the Houses of Parliament, quote, to determine the regularity of their own internal proceedings. I quote from Lord Simon in the Pickin case at page 799A. So
However, of course, Parliament needs to have, in your scenario, it needs to have the opportunity
it does.
to do that.
It does.
So it would need to meet as soon as possible in order to decide what it's going to do next.
Exactly so, my lady. And I emphasise, although we are seeking only a declaration, it's an important declaration. We would ask the court, if it's with us on the merits, to give an indication, if the court thinks it appropriate, an indication of what the court expects now to happen. That is, for Parliament urgently to meet so that Parliament can decide what happens next.
Can I ask,
yes,
would Parliament have power to determine that it had not been prorogued and then to save all the bills that were lost or seemed to be lost when the purported prorogation happens?
In my submission, Parliament would have power to do what it thinks appropriate in this most unusual situation, and were it to decide that by reason of the prorogation having been based on unlawful advice, if the court's with us, from the Prime Minister to Her Majesty, that it would then, in the view of Parliament, to be appropriate to treat the prorogation in parliamentary terms as null and void, then that decision could not be challenged in the court, because that decision would undoubtedly be a decision that was a decision concerning the regularity of their own internal proceedings. And I am submitting that the appropriate way forward in this unusual and difficult circumstance is to let Parliament sort out the problem. But it can only do so if, first, the court grants a declaration that the advice was unlawful, and if the court with great respect, thinks it appropriate to do so, encourages the Prime Minister to ensure that Parliament meets as soon as possible next week. If unhappy...
But does the Prime Minister have to do anything to ensure that Parliament meets next week?
Well, it may be that the Speaker of the House of Commons and the Lord Speaker in the House of Lords, if this court were to declare speedily that the advice was unlawful and that this court is not going to give any further remedy because it expects that matters will be dealt with in Parliament, that the Lord Speaker and the Speaker of the House of Commons will take action to ensure that Parliament reopens as soon as possible next week. It's a matter for them. And then Parliament can debate, and Parliament will decide exactly how it wishes to proceed. And in my submission, that is the appropriate way forward. It's not for this court, I respectfully submit, to become involved in those matters unless it really has to, unless the matter needs to be looked at further.
Well, I quite understand that, but do I correctly understand your submission that if a declaration of unlawfulness in relation to the advice is given, it doesn't require any intervention by the Prime Minister? It's really a matter then for Parliament.
That would be my submission. It would be a matter for the Lord Speaker, the Speaker of the House of Commons, to decide how best now to proceed. They would know, in that contingency, they would know that this court, the Supreme Court, had ruled that the Prime Minister's advice, which led to the prorogation, was unlawful. They would know, if the court were prepared so to indicate, that the basis of that declaration was that the court took the view that the parliamentary scrutiny was required for legal reasons, and no doubt politicians and others would be asking the Speaker of the House of Commons and the Lord Speaker to reassemble Parliament so that Parliament can decide as soon as possible next week how they think, how Parliament thinks it best to proceed. This court would have done its job and it would then be back to Parliament. All that could stand in the way of that would be if the Prime Minister, and I very much hope that this is unrealistic, that the Prime Minister hears of a declaration, hears of indications from the court that says, well, I'm simply not going to take action. In those circumstances, we would submit that it would be open to the Speaker of each House to reassemble Parliament, if they so wished.
He doesn't have to take action on your submission.
In my submission, no.
I'm just wondering about the possibility that this might lead to a further constitutional clash. The implication of Lord Keane's submissions, as I understood them, was that even if this court were to declare that the advice was unlawful, Parliament would nevertheless stand prorogued, because the prorogation, he submits, is nonetheless effective. And following that logic, Parliament could not meet again unless, I suppose, a proclamation were to be made under the 1797 Act, which would have to be initiated by the Prime Minister.
My answer to that is if the court gave a declaration, and even if the court, as I'm suggesting, gave no further remedy, it would be implicit in that what followed from the advice was infected by the illegality, the unlawful nature of the advice. And if it were thought appropriate by the Lord Speaker and the Speaker of the House of Commons, notwithstanding the view of the Prime Minister, to reassemble, there could be no legal challenge to that. Parliament would be deciding how best to proceed. There could be no legal challenge to any decision that was made by Parliament itself as to what to do next. That's my submission.
I just wonder whether people don't need to have a clearer view, whatever the outcome of these proceedings are, where everyone is left. I mean, if we uphold your appeal, isn't it going to be very important, not least because of the time constraints which you've urged upon us, that it's very clear who is the person in law from whom further steps are required. Is it the Prime Minister, which it would be if Parliament is prorogued, as I understand it, or is it the Speakers, which it would be, as I understand it, if Parliament was not prorogued? Don't people need to know where they stand a little bit more clearly than you're indicating?
Our concern is that time is passing. And if this court is going to make a ruling on these questions, it will inevitably, we fear, take this court longer than if this court simply decides to declare illegality.
Just make an assumption that whatever this court thinks the answer in substance is to these proceedings, this court will produce that answer as soon as it humanly can. Make that assumption.
I'm very grateful. I've made my submissions. It's self-evidently a matter for the court how it thinks it best appropriate to proceed. My submission is governed not just by questions of time, it's also governed by the standard approach when we come to remedies, as my lord better than most knows, that the court only does what it needs to do. And it doesn't do more than it needs to do. But I take your lordship's point. It may be helpful, probably would be helpful, for the court to say as much as it can within as speedily as possible in relation to these matters. Clarity is very important, so everybody knows where they stand. I entirely take the point that my lord is making.
If the advice was unlawful, has there nevertheless been a valid prorogation?
Yes.
Can we duck that?
I'm not suggesting that the court ducks it. I'm politely suggesting to the courts that it does as much as it can, as quickly as it can, if it's with us on the merits. And the danger, the concern, is that it takes the court a lot longer to resolve that question than simply to give a declaration and an indication. And time is passing. We have already lost, effectively, 2 weeks of the 5 weeks.
But your submission, Lord Planning, surely has to be that if the advice is unlawful, then any action taken upon it cannot be valid.
It is my submission. It is my submission.
And although you're not asking us to go further, there is an order in the Scottish proceedings to the effect that the prorogation is of no effect.
I take
and we're being asked by Lord Keane to recall
that is also
that order.
That is true. But I'm anticipating, this may be impertinent, that the court is going to give an answer as soon as possible, as soon as humanly possible, to use the President's word, but it's going to give a reasoned decision at a later stage. I assume that the court is not going to produce it all in one go.
Make no assumptions
I make no assumptions.
whatsoever.
I make no assumptions. We are asking the court to do whatever it thinks is appropriate in these circumstances. I've made my submissions, but I take my Lord's Deputy President's point in relation to this, and I take the point made by Lord Sales and Lord Wilson.
I may have misunderstood you, but when you talk about a declaration of unlawfulness, does that extend only to the advice or also to the standing of the order in council?
Well, we have asked only for a declaration that the advice of the Prime Minister was unlawful.
Yes.
But, as is put to me, it is an inevitable consequence of a conclusion to that effect that the order in council was also unlawful, if I be right, that Article 9 can't protect it because it's not a proceeding in Parliament. That's how I put it.
Okay.
Is it possible that there's a sort of two-stage solution? Because what you're suggesting is a course that might avoid another major constitutional question having to be resolved on this appeal. Yes. Namely, is it the court which has jurisdiction to give relief, or is it Parliament's sole prerogative in relation to the conduct of its own proceedings? Is it a two-stage matter, possibly, that if the court were minded, and I'm certainly not giving any indication, to be in your favour, then it could defer that question to see what happened or what?
Well, that's was what I was submitting to the court when I started this submission on remedy, that the appropriate way forward may be for the court to give a declaration, if it's in our favour on the merits, to give an indication of what it thinks now ought to happen over to Parliament, but if necessary, the court would have to inevitably have to deal with a further thorny constitutional question of whether further relief is appropriate. But that may be unnecessary. It may be that in the light of a declaration and an indication, this matter can be resolved in Parliament.
Well, I'm sure that Mr. O'Neill would say that he's asking us to uphold the interlocutor of the inner house.
Yes. 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 Well, I'm grateful by Mr. Fordham that paragraph 17 of the note that the Prime Minister and the Advocate General for Scotland presented to the court this morning, paragraph 17, does say that the court may find it would be unlawful for Parliament to remain prorogued for any further period, and that advising the Sovereign to bring forward the meeting of Parliament pursuant to the Meeting of Parliament Act 1797 is the only option lawfully open to the Prime Minister. In that event, a declaration would be sufficient on the basis the Prime Minister would comply with the terms of a judgment having that effect. So, as I understand it, if the court were to indicate that that's the only option lawfully open to the Prime Minister, then the Meeting of Parliament Act provides the answer.
But then all the bills would have fallen.
That is, yes, subject to Parliament deciding that in these exceptional circumstances a different approach ought to be taken.
Well, we will have to decide what the answer is, and we will have to decide in one way or another what the consequences of that answer are.
So, my lady.
It's not... none of this is easy.
No, I don't suggest it is, and that may be why the suggestion of my lady, Lady Arden, which is what I was grappling towards when I was opening these submissions on remedy, may be the best way forward. One takes it in stages. But that's a matter, of course, entirely for the court.
So you'd be asking effectively for a limited declaration, meantime, with leave to apply?
Yes, with leave to apply, and if the court thought it appropriate, an indication of what the court hopes and expects will happen next. And if it doesn't happen, then the court will need to grapple with the question of whether to grant further relief, which we hope will not be necessary. Those are the submissions on behalf of Mrs. Miller, unless I can seek to assist the court further.
No, thank you, Lord
Thank you very
Henry.
much, my lady.
And thank you to everyone who's been involved in the preparation and presentation of these cases. A great deal of work has gone on behind the scenes to ensure that the large number of documents, the parties' written submissions, the relevant materials, the authorities, could be made available to us in an organised form and in a very short time. We appreciate that. We're also grateful to the Council who have addressed us for their oral submissions and for largely keeping to the timetable that the court had set. And we recognise the demands that this hearing has placed on the court staff and everyone else involved. I must repeat that this case is not about when and on what terms the United Kingdom leaves the European Union. The result of this case will not determine that. We are solely concerned with the lawfulness of the Prime Minister's decision to advise Her Majesty to prorogue Parliament on the dates in question. As we have heard, it is not a simple question, and we will now consider carefully all the arguments which are being presented to us. But we also know that this case must be resolved as quickly as possible, and we hope to be able to publish our decision early next week. Thank you again, one and all. The court is now adjourned.
Thank you.